So we're going to start with the question of how does one gauge if the time is right to go to mediation, and how does one encourage your client to go to mediation? I'm going to start, Andrew, with that question to you.
Well, thank you, Hetty. Good morning. Good morning, everyone attending. It's really nice to be here and to see so many familiar names on the participants list. It's a really good question, and it's a question that's asked an awful lot in terms of when is the right time? Is it the right time? And I always take the view that the sooner the better. But I think a different way of looking at it, perhaps, is that any time is probably the right time for a client. And the reason I say that is it's very easy, and it was certainly easy for me as a barrister to forget, and I often put a mirror up to myself when I'm mediating, but to forget that it is the client's case, and a client bringing a dispute to an end puts the client generally, if not almost always, in a better position than remaining in the dispute. And it's hard to think of any time when a client will turn around to a lawyer, a case having been settled, and say that you should never have settled that. I really wish I was still in dispute. I really wish I had the trial coming up. I had something to look forward to. That generally doesn't happen. So perhaps one of the ways of looking at this, and I think this is where, and again, holding a mirror up to myself, and where I think lawyers perhaps often forget to do it. The question is, when is the right time to start having a discussion with your client about mediation? And I think that the obvious answer to that is from the very beginning, because when a client comes to you with a dispute, that is the time to be discussing all different aspects of how that dispute might pan out, what you might have to do, what it's going to cost, and most importantly, what are the options for the client. And if you introduce mediation at an early stage, and at the earliest stage in those discussions, you then bring the client into that decision-making process. And I know all too often now, mediating generally week in, week out, I find when I have my preliminary discussions with the parties, and I always encourage the lawyers to bring the clients to those discussions, that very often, not always, but very often, the first the clients are really learning about mediation is when they see me. And it doesn't matter if the dispute's been going a matter of weeks, months, or even years. It's quite clear to me that they've never really had those discussions and never had it in the back of the mind. And so I think when deciding, and the second part of the question, encouraging, if you're having those discussions from the beginning, you're putting that option in front of the client at every stage. You're asking the client to be part of that decision-making process. And you're telling the client that this is a way to bring it to an end. The court, the litigation, the arbitration, whatever, will also bring it to an end. But this is an option. And you can have those discussions as to what it means to mediate, what the aim is to settle. But the very fact, and I think the encouragement, what do you encourage your client to do? You encourage your client to take control, and you encourage your client to have the option themselves to talk about the dispute. And the time then will come automatically. And going back to where I started, it's always, I'm finding, and I'm sure we'll cover this a bit later, that the earlier you get to mediation, the easier it is to reach a settlement, because parties are talking about the actual reason they're in dispute rather than the legal side of the dispute itself.
Do you share those views, Rebecca?
Very much so. I endorse what Andrew said, and good morning to everyone, good afternoon, good evening, depending on where you're joining, and lovely to see so many familiar faces, so many familiar names on the attendee list. So I absolutely, is it too early? Is it too late? A few thoughts on that. Is it too early? Many cases I mediate don't actually have any proceedings pending. And so the benefit is that little time and money has been so far invested in pursuing the claim. So the result of that is that the people themselves are actually less invested in litigating, and they've got a more open mind. And there is also a bit of psychology in this, that actually the more times people say something, the more they believe they're right. So there's a real moment to nip it in the bud before people have actually said it too many times the way they're looking at their case. Sometimes it can be difficult that actually each party will say, look, I don't actually really know what my case is, or the other side, the defendant, may say, we don't really know fully what the extent of the claim is if they're potential defendants. I mean, yes, there are the pre-action protocols designed to pre-warn and inform, but it certainly isn't a perfect process. And what I've actually found in that situation is that sometimes it may be a two-stage process for the mediation. So a recent case I had, recovery of capital investment into a joint venture, and somewhere there was a sort of side glance of a potential counterclaim for fraud. So at the mediation, we explored how serious this potential counterclaim was, and it was actually looking really quite chunky. So it was agreed that we would adjourn for 4 weeks for those allegations to be fleshed out, and then there was a further mediation, and the matter then settled. Just on the other end of the spectrum, you know, is it too late? I think it's probably never too late. I've had cases settle when the trial is just 7 or 10 days away, you know, almost at the trial door. And why might that be? Well, saving the costs of going to trial. It may also actually be that the client realizes the reality of going and being a witness and being cross-examined. I actually had that when I was an executor defending a large Inheritance Act claim, and it settled on the first day of trial when the judge was reading the papers. Why? Because firstly, there was a last-minute change of counsel for the claimant who took a very different view on the strengths and weaknesses of the case. But also, one of the key witnesses just came along and said, you know what, I just cannot face being a witness for a day in the High Court. And of course, you know, a settled client is a happy client at whatever stage it is.
That's really interesting, thank you. And I think, Andrew, your point about it being a conversation right from the start will hopefully come in with the change of culture that Lady Justice Asplin has mentioned this week in her introduction to the Civil Justice Council's report on compulsory ADR, putting mediation fully in the toolbox alongside other means of dispute resolution. So if you've got a reluctant client and you need to choose your mediator, how do you go about persuading your client that mediation is the way forward and choosing the mediator, Rebecca?
So yes, I mean, picking up on the report of the Civil Justice Council, at the moment there is of course the issue of an unreasonable refusal to mediate may mean risk of cost penalties later. So that's already a compelling argument, and that's going to be enhanced probably by the stages, as you've mentioned, Hetty, with what's happening in the ADR picture generally. But I think in terms of agreeing a mediator, clearly to go to a mediation provider takes away the individual views of people. But if actually the other side proposes a mediator, I would say consider carefully going with that suggestion. Unless you have a really good reason not to go with it, then consider going with that mediator that the other side has suggested, because if they've worked with them before, they're going to have built up trust in them, and they're more likely to work well with that mediator. And that's got to be a good thing for you and your client. And also the mediator will have their ear, you know, they're going to listen to the mediator. And that's again, a plus point. But I'm also very conscious that, you know, when I was a solicitor and used to appoint mediators, I know that the choice of mediator will reflect on the solicitor. Just like making any recommendation, you may have had this case for a long time, and then you're going to bring in this external person for a day, and how is that going to go? But a good mediator is going to work collaboratively and professionally with all the advisors. And if there is a weakness in the case, that can always be discussed in private caucus and factored into the risk assessment that would be looked at privately in the room.
And Andrew, what about your thoughts on choosing the mediator and actually persuading your client to go to mediation? We've had, I don't know whether you've seen the question in the chat.
I have, from Salma. Yeah. So it's interesting, and it's constant, and I know from talking at to the clerks and the practice managers at IPOS, it's a regular thing that one side will contact and say we want to go to mediation, but we're not sure if the other side yet wants to. And I know from when I get the papers in mediation, and sometimes the parties are kind enough to include correspondence that I don't necessarily need to see to help me in terms of being a mediator. But it is interesting to see the debate that has gone on between parties on two things. One is whether they actually should go to mediation. And the second is when and if they have made that decision that they will, then the arguments that ensue in terms of the mediator. And it's very easy for me to say as a mediator, perhaps when I'm going to say it, you don't need really to have those arguments. I think that, you know, the jury is no longer out on the question as to whether mediation works and whether mediation is successful. And I think the majority of litigators know that a vast majority, and certainly in the work that I do and Rebecca does, and you, Hetty, commercial mediations, that matters go to mediation. So what's happening is something different. It is actually, as Salma has asked this question, it's one side taking a stance.
So Salma's question is, she's received a response to a letter of claim in which the proposed defendant, a professional, refuses mediation ADR. It seems they're refusing because they want to make their denial of liability stronger. How do you suggest I change their minds?
Yeah, well, it's a really good question. And so there is no way, or let me hazard a guess, there is no way that individual who has sent that to you doesn't know that mediation is used, and it is a flexing of muscles. And I think it's part of this discussion process of saying this is not being scared to say, this is not simply something that I, as the lawyer, am suggesting. This is something the client wants to do. And may I suggest that you discuss it with your client, because we think that the best option in terms of this debate is getting them into a situation of mediation where an independent person can deal with it. But I think, going back to what I was saying, I think it's trying to sort of perhaps sidestep it, not having the argument about it, putting it forward as a really positive process that can take place. And the other part of the question, Hetty, that you asked was agreeing the mediator. I really second what Rebecca said. It is, if one side says, look, I know this mediator, I've worked with this mediator, he or she does a great job, that's a good indication. That's shouldn't be alarm bells. You'd say, well, they're going to be in your camp, because a good mediator won't be in any camp. I often use the phrase to explain my independence: I don't care who's right or wrong. And that sometimes gets funny looks, but it is the absolute truth. But I think there's one other factor, and I know that this is a regular feature. It's those who are acting on behalf of their clients who want to go to mediation have to show how serious they are about it. And one of the things is, which I think is really important, is the lawyer who has control of the conduct of the case is the one who starts making the contact with, for example, IPOS in terms of the mediator, and starts having discussions. And all too often, it might well be a trainee, even a paralegal, and they can't have the necessary discussions with the clerks as to, well, the clerk says, I recommend this mediator. And then a discussion should ensue. Well, why do you recommend that mediator? Has that mediator done any of this type of work, etc.? And the more that you know about the case, the more you can actually quiz the IPOS clerks on who's good for this mediation, etc. And the reason you're doing that is then you can go to the other side and say, I've had these discussions. This is why they've recommended these three. And these are the three they've recommended. And these are the reasons. And I think that gives it more force and then helps you in terms of persuading the party and getting to a decision making as the mediator. And the last thing I'd say is, because I see it too often, it costs a lot of money to keep arguing over whether you should go to mediation, and it costs a lot of money arguing over which mediator it should be. And that can be saved, because the sooner you get there, the sooner you can actually have the mediation and see if it's possible to actually reach a settlement.
I totally agree with everything you both said there, and I think we do often find ourselves at IPOS mediating the mediation, and we'd like to see ourselves as essentially the one-stop shop for expert mediators. So so that you can come to us, as Andrew suggests, and say, I've got this type of dispute, who do you recommend? And we can give you 3 names, and you can give 3 names to the other side, and whichever one they choose, then that's the mediator. Or we can decide the mediator for you if it gets to that point, which we have had to do in certain circumstances. So that's really interesting. We've had a couple of questions on the chat, and I think we will come back to those in a moment, actually. But we're just particularly as we now move on to talk about who should attend the mediation. And I'm going to start with Andrew, because it is always a big question: is should counsel attend? Do we need counsel there? And I'd be interested to hear your thoughts first, Andrew.
Well, that's a question I'm asked a lot. As counsel, I was always felt offended when I wasn't invited to a mediation. And I guess what I've seen as a mediator over the last few years, it is perhaps the reason why I wasn't invited always. I think what I'm seeing is 50-50 in the type of mediations I do, with counsel attending and counsel not being there. And I think for me, the short answer, and the answer that I've adopted, is I'm often called by a solicitor on one or both sides and saying, we don't know whether to bring counsel, what do you say? And I say it's obviously your choice, it's the client's choice, it's an expense. But for me, I put back a question to them and say, do you consider that your counsel is mediation friendly? And that sometimes that's faced with a question to me, well, what does that mean? And what it means is you are investing in a process. That process has an aim, and that is an aim to bring a dispute to an end. And you want to have participants in your room who sign up to that process and are going to be what I think mediation friendly, are going to work with the mediator, are going to work using the process, and are going to do everything that they can to move the process towards settlement. Settlement isn't always possible, but do everything they can to move it towards settlement. And counsel are often isolated. One of the worst things is if I had a mediation recently where counsel told me that, I said, look, please, if we're going to have a joint session, don't just repeat what's in the mediation. I don't call them position papers anymore, I call them mediation statements. I was assured that that would not happen. And in a sense, it didn't happen because, well, it did to a large extent, but what we also got was about 30 minutes of reading from authorities. And that put the whole process back. He didn't do anything at all, and that is not mediation friendly. The authorities were mentioned in the mediation statement. They could have just stayed there. We didn't actually have to read what Lord Justice said about this or that. But equally, I've had fantastic counsel who realise the best thing for the client is to get a settlement, and work incredibly hard. But counsel isn't your only choice. There's other people you have to think about being at the mediation, and I'll let Rebecca pick up on that. But the key is giving it thought. And all too often there are people who are not there who should perhaps be there. And I think that's it's spending a bit of time making a decision who's going to be there. And now in this new world, it can be hybrid. So the mediation I did yesterday, I was face to face, but in both rooms we had people dialing in via Zoom, and it worked fine. There was no problem. It was as if they were in the room. So there were a couple of key people who weren't actually there physically, but were there the whole time via Zoom.
Really good. And Rebecca, what are your thoughts on that issue?
Thank you. So absolutely endorse Andrew's view that barrister and solicitor can actually be jolly helpful. Most of my mediations, there's at least the solicitor, but I'd say about half the counsel there as well. And I definitely don't think it's overkill to have a barrister there as well, as long as Andrew says, the team is working well together and working in the interests of the client, and remembering that the whole purpose of mediation is to look for a settlement if it's going to be satisfactory for both. But dealing with the other people who might be there, and certainly my experience of mediations on Zoom in the last sort of 16 months has been that the numbers of people attending has mushroomed, because it's so easy for people just to say, yes, it's so easy, they can join, but they may not necessarily attend for the whole day. And it can be helpful, but I think the old adage of the more people you have around the table, the harder it is to get to a decision, I think that still plays out. So I would be thinking about choosing the people carefully. And when it comes to the client, I think having one reasonably senior key decision maker is often the good approach. Sometimes even it can be good to have someone who's a little bit removed from the real detail and history and sort of angst of the dispute. So I had a recent care home franchise dispute where the finance director attended, and they were a recent appointment. They hadn't been involved in the past and the history, and they came in and they were able to assess the risk, which is really what you're doing at a mediation, and make a big picture decision without the emotion of the past. And so actually, whereas the other party said, really, how can they come to the mediation and make a decision? It actually worked very well because they were one step removed. But I think if you are going to have more than one person, try to have people coming from the client of a similar approach, because otherwise you could get into the problem of a split room, and before you know it, the mediator is mediating in one room between two individuals in that room. And that's actually also, I'm finding, can happen particularly on Zoom. So for example, a big freehold company bringing a claim against multiple leaseholders for service charges, and one of the directors was a resident of the block. So they had a lot of personal views. They were living there, and actually the mediation was happening all around them with others joining. Whereas other directors were investors who had these properties as long-term investments. And the two parties had very different, or the two individuals, groups of people had different views. But actually what brought it all together was having the managing agent there, which was a clever thing to do, to bring the managing agent who could then bring this overall view as to what would be in the best interests of the property. But I'm interested in the question from Joanna Wallen, who says, how would you deal with the other party agreeing to mediation but being sick and not attending, and only their lawyers in attendance? I've had this sort of thing where I've been at the mediation and then one of the parties just doesn't attend. It may be that they're available by phone, which is what you want, or in some way. And generally, I've always continued. I've discussed it with the other side, who are of course dismayed, and there are questions of, are they buying into the process? Is there goodwill? But in my view, if you've got the attention of their lawyers and they have the ability to take instructions, it's better than nothing. And actually, I've had mediations where that has happened and it's gone ahead and there has been a settlement.
Thank you. Thank you. And thank you, everybody, for your questions. Keep them coming, because it's great to hear from you. So how do we prepare our clients for the opportunity that mediation presents and to make the most of that opportunity? Rebecca, what are your thoughts on that?
So thank you, Hetty. I mean, I think preparation is absolutely key. And I think getting the client into the mindset that the day of mediation is completely different to the litigation process. And what they should be looking for is peace, not war. And they need to come with an open mind and actually to expect the unexpected, because quite often things can take quite a change during the course of the day. For example, I've had a lot of cases lately between directors and shareholders, disputes about running the company. And the day begins with one party is adamant they're going to buy the other out. Guess what? By about 3 o'clock, 4 o'clock, common tactic, tables turned around, offer or offeree reverse their positions. If that price is good for you to sell, maybe that's also good for me to sell the other way around. And that can do that volte fast. But I think also it's to say to the client, this is not about history. This is about looking forwards. It's not about going through and reciting everything that's happened. It's actually about a risk assessment and dealing with uncertainty, but making decisions against uncertainty. And I think the other thing is patience, saying to the client, you know, come with an open mind, but come not necessarily expecting that everything is going to be moving in the direction you hope straight away. It can often be that mediations take a bit of time to warm up, and that's actually a good thing. It's necessary for each party to explore with the mediator really what are their options, where are they coming from, what are they thinking to do, and then it may well be that the thing warms up and significant progress can happen as the mediation day continues. So come expecting really a very different experience to what it might be if a party were to go to court or arbitration.
Thank you. And Andrew, what do you have anything to add to Rebecca's wise words?
Yeah, well, they're very wise words, and I of course agree with all of them. For me, I think there needs to be more lawyers whether it's solicitors or barristers, need to work harder in educating their clients about mediation. I talked about if you start talking about it at the beginning, then they'll have at the beginning of a dispute, then they'll have an idea. But if you haven't, to talk to them about the mediation process, talk to them perhaps about the mediator if you know the mediator. And Sam was asked a question about attending a mediation and realizing that the other side's lawyers knew the mediator. The mediation I did yesterday, I knew counsel on both sides. I knew them as counsel at the bar, but I also knew them as counsel because I'd mediated disputes with both of them. And that was an absolute positive, because when I was in each room, I was able to say, well, of course, he or she has mediated with me before. They know the way I work, etc., etc. They know why I'm doing this. But it's possible to have those discussions beforehand with the client about how the mediation process is going to work. Encourage the client to interact with the mediator in the preliminary session, not to be scared to ask anything. No question is too stupid or too dumb. It's much better that you are asked the question. But I think the other thing is, don't wait to the mediation day to have that session to talk about settlement with your client. So very often, and I'd say all too often, I may go into a private session, whether it's on Zoom or face-to-face, and I'm told we need an hour with our client to have a discussion about the case and what they might want to do. And that needs to happen beforehand. Or something will happen in the mediation that isn't so far out on left wing or whatever, but I'll go into a room and it's quite clear to me that the lawyers have not discussed that argument, which was perhaps on the pleadings or in the statement or somewhere was quite clear, hasn't discussed it with the client. And you have another situation and say, well, we actually need to have quite a discussion on that. And that goes all the way through, because what you should be thinking about in terms of at a mediation is parameters and settlement parameters. And that it can be quite an involved discussion. It involves your view on liability. It involves discussing what the other side's view is on liability. And it allows the client to be in the best position that when something happens, and that something might be a proposal or an offer, that they already have the tools with which to deal with that, rather than starting from sort of ground zero. And I think what's often missed, and one of the things, it seems that mediation is this really long day and it's drawn out and it can be quite boring, and we're going to have these huge gaps where we can do all these things. But the reality is you're trying to condense a dispute that may have been going on for a year, 2, 4 years, whatever, into this one day. So things actually, although at times it can appear boring, happen quite fast. And the more you have discussed with your client the various different options, the more you can move at a faster pace and get to a comfortable position where either party can then make the decision, is this where I want to be? Is this where I can settle? And lawyers are keen. Of course, we can't in this country, we coach our clients, but we do quite a bit of work when we're going to trial with our clients. And that doesn't seem to happen as much with mediation. And I think that is it's certainly worth the investment. So that's what I would encourage all the way through.
I think you're absolutely right on that. And we often say to parties who have either reluctant clients or are just unsure, you can speak to your mediator both before appointment and after appointment. And all of our mediators are so happy to have those conversations with the clients as well. And I think that's something that has been beneficial with Zoom, is that is happening more often where we have these pre-mediation sessions to get used to the technology, that we as mediators are also meeting the clients more often. And it's really beneficial because you hit the ground running on the mediation day. But what happens if you're going into a dispute and going into a mediation and the party holds an utterly opposite view to yours on the merits of the dispute? How can you approach that? How can you get started on trying to resolve it if that's the case, Andrew?
Well, there's something that I've actually, those who've mediated with me, apologies because it's a bit of a scratch record, but I think a lot of when I became a mediator, it opened my eyes. It opened to my eyes as how I was as a mediation advocate, how I was as counsel. And one of the things it really opened my eyes to is when I was doing a case as counsel, and I'd sort of made a decision or advice as to the case, I was obviously right. And it didn't matter how good the lawyers were on the other side, they must know I was right. And so if they were taking a contrary view, well, they're just pretending that they can't really believe in the view that they're taking. And what I've seen at mediation is that was, I'm being over naive about it, but what I see very much at mediation is how much belief there can be in the rights of each side's case. Absolute conviction. And no making it up, no bluffing. Both sides believe in it. And it sort of takes me back to when I was at university and a professor said, I know you're all impressed by the law books. There was no computer at the time. We were in a law library. And I remember him saying, now look again at all those books and remember that 1 in 2 of those people who stepped into the Court of Appeal, House of Lords as them words, were proved to be wrong. And so I think that the point I'm getting at is just don't fight the fact that the other side believe in their case, because they're just the mirror image of you, and recognize that they believe in their case. And there will be a stage of the mediation that will be quite dogmatic. You sometimes have to go through it. I sometimes go into a room and say, look, it's really important that you hear each other and you hear how convicted each side is in terms of their view. And you listen to what the other side, and you do the other skill, which is hear what they have to say. Because if you actually understand that the other side believes in their claim or their defense of the claim as much as you do, that will help you to move to the next process. Because what you'll then have to do is realize, I cannot use this mediation to prove that I'm right and they're wrong. And so we're going to have to agree to differ at this point. And we're agreeing to differ because there's no judge. There's no judge, he or she, who's going to tell us who's right or wrong. So we're going to have to actually put the merits to one side and then work on what can we then do if we're going to bring this to an end. Because the other line is, when I'm in each room, I often say this phrase, when you tell me something, I accept you're right. I'm not going to argue with you. And let's say you are right. What happens if a judge gets it wrong?
Yeah.
So you may be 100% right, but a judge may get it wrong, or vice versa in the other room. So let's park that, because it can happen to both of you. And what can we now work on to see if we can bring this matter together? So the key thing is, if they're dogmatic, if they're passionate about their case, accept it. You two are. The only reason you think they're dogmatic is probably because you believe in your case so much. And it's just a mirror image of yourself.
Yeah, absolutely, absolutely. Rebecca, what are your thoughts on the opposite view and working around that?
So completely agree with what Andrew said, and absolutely. But of course, we have to remember that merits are just one piece of the jigsaw. So it may be that there's a different view on merits, but there's all these other pieces of the jigsaw that are at play at the mediation. Appetite for risk, financial ability to pursue a claim or to pay. How does a conflict-free future look for each party? Is one actually wanting to retire and sell out? What are their health issues? Can they cope with stress and uncertainty? All these things come into play in assessing really where is a sensible place for a settlement to lie. So even if people have very strong views on the merits, there are going to be all these other parts that help them to make a decision in terms of where is it sensible to settle. And I remember my very first experience at a mediation was as a party to a mediation. I was a developer, a property developer, and there was a claim by a purchaser of a property who seemed to be absolutely convinced that everything they said about the property, there were difficulties. And I went to the mediation and I thought, how is this going to work? This person is absolutely convinced they're right. What happened was the mediator spent a significant amount of time with the other party, presumably talking through the likelihood of the success of their claim. And guess what? The matter settled.
We've had a question from Laura. She's asked, how do you handle a defendant who is lying about the facts of the case, such as saying we called no more than 4 times per week when there is a call log showing daily calls? Rebecca, are you just having a look at that one?
Just finding it. Haven't seen it, but
Is it the Q&A?
Thank you. So, of course, as a solicitor, if you are put on notice that your client is lying, then that may raise issues of conduct and should you continue to act. Otherwise, I think it is to find out what actually is behind it, and sometimes it can be a question of unpicking what people are saying and what's behind it, and sometimes there can be a misunderstanding, so it's perhaps to look into more detail. But on the other hand, it may just be to take a broad view as a mediator and to say, how relevant is that actually to today? Because you get quite a lot of sideballs coming, and it may be just to say, shall we park that and look at the bigger picture of what you're trying to achieve here?
I think that's absolutely right, and I think you can sometimes spend quite a lot of time getting really into the nitty-gritty, and then you have to take a step backwards as a mediator. Don't step back as a mediator and look at the bigger picture and move on. But those conversations often go to risk, don't they? The risk that a judge will go one way or the other on a decision. Okay, well, I'm aware we're running a little bit short of time, because we'd like to have 10 minutes or so with you all in a networking session afterwards, if we have time. But actually, we've got a couple more questions which I'd just like to ask you both. John's asked, would the panel agree that there needs to be a willingness to compromise in all mediation cases? Can you give a one-word answer to that, Andrew?
Yes. It is the one word. And settlement is a compromise. And the classic line that's often used is both sides go away feeling slightly aggrieved. Or the next day you wake up and think, well, if I'd gone to court, I could have paid less, or if I'd gone to court, I could have received more. And that means you compromised. You haven't got everything you perhaps thought you were entitled to, or you perhaps paid a little bit more than you thought you perhaps should. But it's everything else. The dispute, if you're the client, the dispute has gone. And the magic of mediation is if you're having that thought lying in bed, by the time you get downstairs, that next day after the mediation, the coffee tastes better.
Yeah.
And coffee tasting better is really the magic of mediation.
Rebecca, do you agree? Do you think there needs to be a willingness to compromise in all mediation cases?
Totally. I think coming with an open mind, absolutely willing to look, also willing to look at where the other party's coming from, an ability to read the other room. I think that helps. But, you know, as they say, no pain, no gain. Yes, there is a bit of pain, but then, as Andrew says, the next day looks so much brighter. And certainly the messages I get the next day from clients and solicitors and barristers of, oh, yes, this is all looking so much more cheery is always a nice thing to receive.
Yeah. Thank you. I've had a question from Rachel. Do you ever sense a resistance to the very concept and process of mediation on the part of some counsel who aren't as keen on mediation and who perhaps would like to keep a case going as it represents important future work and revenue for them? What do you think, Rebecca? Do you come across that, what we might say, as an out-of-date attitude to the acute drop in revenue, which I know is Andrew's phrase?
Fortunately, very rarely. I mean, I do remember in my very early days, my first observation was with a very senior mediator. You have to go and observe someone when you first begin your out as a mediator. And there was a QC there, and at about 2 o'clock, he put his pen down and said, do you know what? I'm out of here. I'm rubbish at this. This is not for me. I'm only good at doing the advocacy and at the court, and I'm out of here. And he put his coat on and left. And he said, if you need me, I will come back from chambers and draft. And he clearly recognized that this was not his mindset. And that was a surprise for me. There was then the issue that the others said, we see the barrister has left. Are you actually serious about continuing with the negotiation? So that had to then be dealt with in a diplomatic way. But fortunately, that's the only time I've actually really witnessed that. In my experience, barristers are working towards getting a deal and are willing to look at it to find something for the client. And I think they see that, you know, a happy client is a satisfied one, and that there will be plenty more on their way.
Yeah. Do you have a quick answer to that, Andrew?
Yeah, I think thank you, Rachel, for your question. It's not just counsel. I put counsel and solicitors in the same boat, and it comes back to what I said. There are mediation-friendly lawyers, and there are those who aren't. And you're absolutely right. And as Hetty said, the elephant in the room is ADR often, for some people, still means acute drop in revenue, or they perceive it to mean acute drop in revenue if they settle the case. I mean, I personally feel, and I hope I did go by this mantra when I acted as counsel, was that the best gift that you can give to any client is the gift of settlement. No one wants to be in dispute, whether it's a legal dispute or dispute in their lives, whatever. It's not fun. And for me, it sounds like a cliche, but the gift of settlement keeps on giving. Because if you do something that is good for a client, there will be future work. And I think, you know, majority of lawyers see that. And the majority I'm seeing, I have to say, I've seen quite a change in the last 15, 16, 17 months, whatever it's been, to what I would say are more mediation-friendly lawyers because of Zoom. And partly that's because of necessity. So what's happened is there were delays in the court, and they've realized they have to do something for their clients, and they're making use of mediation more. And so, you know, situations changed, but you know, there are exceptions. But generally speaking, I find that most lawyers are generally mediation friendly.
Perhaps because you don't see the ones that don't come to mediation.
That could be a very good reason. Yeah. There's always the odd few who aren't, but
yeah. We've had a question from Peter. What value, if any, do you see in the opening statement, particularly where both sides are happy to dispense with this? With an eye on the time, Rebecca, what are your thoughts on opening statements?
Yes, briefly, I think it's an opportunity for the lawyer to speak to the party on the other side as much as the other lawyer. By the time you get to mediation, there will have been plenty of correspondence between the solicitors, and the barristers will have been involved. But it's actually an opportunity for that party to hear directly from the lawyer on the other side exactly how they're seeing things. So to that extent, I think it can be very useful.
Thank you for your questions. Andrew, do you have a thought on opening statement?
Yeah, well, you know, I mean, not every IPOS mediator agrees with me, but I've done away with what I call the opening session. Because I think if you just start with everyone in the room, you get people saying, I'm right, you're wrong, I'm good, you're bad, etc. But I'm a huge fan of joint sessions. And I don't think there has to be a certain time for it. What I think is, if you, as a mediator, have spoken to the parties, had 1 or 2 sessions, you then can say to them that when we have this joint session, discuss this. The other side are troubled by this. I think you need to address this point, and vice versa. And then it does work. But what I've realized is, in the last few months, I ask the parties what they want as well. And sometimes they're adamant they don't want, and that's fine. You then work with them, and sometimes they're adamant that they do. So one I did last week, all parties wanted it. They wanted it, and wanted it as sooner rather than later. And we had it because that's what the parties want. And the essence is, it's always them. It's not, in the same way it's the client's mediation, it's not my mediation. It's their mediation. And it worked pretty well. I still had time to have meetings with each party and plant a few seeds of what I thought would need to be discussed. And yeah, that helped. But so mediation is about collaboration, and there is nothing better most of the time, not all of the time, but there's nothing better than getting into a room and actually seeing the person, because we're social beings, and interacting with humans does make a difference to moving towards a settlement.
Agreed. So time is running a bit short, and I'd like to just ask our final question. Rebecca, why does mediation present a golden opportunity for lawyers?
Well, I suppose the settlement rates speak for themselves. It's more than 90% settle on the day or soon after. So that shows that, and if we say a settled client is a happy client, then that's going to find a result. I think it's also an opportunity for lawyers to shine if they help their client to find a deal in a day. It shows that they're willing to step away from the law and the legal process and engage in a rather more commercial and pragmatic discussion. And it just saves a lot of time and money.
Brilliant, thank you. And Andrew, what are your concluding thoughts on it being a golden opportunity?
Thanks, Hetty. I mean, I think it's the gift of settlement that you can give. And what I realize is I come in as sort of the new boy on the block in terms of mediation. The lawyers know about the case far more than I do. And that's something I like to make quite clear to clients when I go into the room, that you have someone in your corner supporting you through this process. I'm facilitating the process, but they're supporting you. And that being the case, for me, it gets that partnership of lawyer and client working better. And what it means is, if there's a settlement, the client does look to the lawyer as being part of the process and being responsible for that settlement happening. And that's why I think it works. And of course, for any lawyer, a mediation I did recently, it was quite clear to me the lawyer was quite concerned for various different reasons about this going to trial. And that mediation presented this golden opportunity for there to be a success for their client in whatever that settlement was going to be. And there was a settlement on that day, rather than this fear that the lawyer had, and I in that case probably rightly had, that it could go disastrously wrong at trial. And so that was the opportunity. I can get you the best result possible today, And if it's not today, in the next week, next 2 weeks, you know, whatever, however long it takes. And that's what happened. And so for that particular lawyers, for many, it was a golden opportunity. And I imagine they woke up the next day and their coffee tasted better because they no longer had the fear that they would go all the way to court and their client would lose.